Hello everyone, and welcome back to Money, Finance, Wealth. Today we are tackling a topic that is profoundly important for every single adult, yet so many of us put it off: estate planning and its most fundamental document, the last will and testament. Before we dive in, if you're new here, please hit that like button, subscribe to the channel and ring the notification bell so you never miss out on our in-depth guides to mastering your finances. We're all about providing you with the knowledge you need to build a secure financial future. It's an uncomfortable topic for many, but thinking about what happens after you're gone is one of the most responsible and caring things you can do for your loved ones. A will is more than just a legal document, it's your final instruction manual, your last act of looking after your family. This video will break down exactly why you need a will, what happens if you don't have one, what goes into it, and the essential basics of estate planning that everyone needs to understand. Let's start with a simple definition. A will is a legal document that outlines your wishes for the distribution of your property and the care of any minor children. It is your voice after you are no longer here to speak for yourself. But right away, many people tune out because of some powerful and persistent myths. Let's bust them right now. Myth #1. I'm too young to need a will. The truth is, tragedy can strike at any age. A will isn't about planning to die, it's about being prepared for the unexpected. If you are an adult with any assets or, most importantly, any dependents, you need a will. Myth #2. I don't have enough assets to need a will. You probably have more than you think. A car, a bank account, some investments, even personal possessions like jewelry or electronics are all part of your estate. Without a will, the process of distributing even these small things can become a headache for your family. Myth #3. My family knows what I want, they'll figure it out. Even with the best intentions, grief can cause disagreements and confusion. A will eliminates guesswork and ambiguity, preventing potential disputes among your loved ones during an already difficult time. It provides a clear, legally binding roadmap for them to follow. Myth #4. A will avoids probate. This is a common misconception. In most cases, a will actually guides the probate process. It doesn't avoid it. We'll talk more about probate later, but the key takeaway is that a will makes the process smoother, faster, and less expensive than having no will at all. So, what happens if you pass away without a will? This legal situation is called dying intestate. When this happens, you don't get a say in what happens to your assets or who cares for your children. Instead, the state you live in makes all those decisions for you based on a rigid, one-size-fits-all formula defined by its intestacy laws. These laws vary by state, but they generally follow a predictable hierarchy of next of kin. Let's walk through a common scenario. Imagine a person named Alex is married to Sam, and they have 2 young children. Alex dies without a will. Many people assume Sam, the surviving spouse, would inherit everything. But in many states, that's not the case. The law might dictate that Sam receives only 1/2 or 1/3 of Alex's estate, and the remaining portion goes directly to the minor children. This creates a huge problem. The children's inheritance would likely be locked in a court-supervised account until they turn 18 or 21. Sam, the surviving parent, would have to petition the court to use any of that money for the children's own upbringing, like for education or healthcare. It's a bureaucratic nightmare that Alex never would have wanted. What if you're unmarried but in a long-term partnership? Your partner gets nothing under intestacy laws. The state will look for your parents, your siblings, or even distant cousins to inherit your assets. Your partner, who may have shared a life and a home with you, could be left with nothing. And what about your children? If both parents pass away without a will naming a guardian, the court will appoint one for them. A judge who doesn't know you or your family will decide who raises your kids. It could be a family member you wouldn't have chosen, or, in a worst-case scenario, the children could become wards of the state. Dying intestate means giving up all control. The state's plan is impersonal, and may be completely at odds with your wishes and your family's needs. A properly drafted will has several key components, each serving a vital purpose. The executor or personal representative. This is the person or institution you name to be in charge of carrying out your will's instructions. Their job is to inventory your assets, pay off your final debts and taxes, and then distribute the remaining property to your beneficiaries. This is a big job that requires honesty, organization, and diligence. You should always name a backup executor in case your first choice is unable or unwilling to serve. Beneficiaries. These are the people, charities, or organizations who will inherit your assets. You need to be specific. Instead of saying, "I leave everything to my children," It's better to name them individually and specify the percentage or specific assets each will receive. A residuary clause is also crucial. This clause names a beneficiary for any assets not specifically mentioned in the will or that are acquired after the will was written, ensuring nothing is left unaccounted for. Guardianship for minor children. For parents, this is arguably the most important reason to have a will. This is where you name the person or people you want to raise your children if you and the other parent are no longer able to. Without this designation, as we discussed, a court will make the choice. You should discuss this with your chosen guardian beforehand to ensure they are willing to take on this incredible responsibility. Trustee for minors' assets. You likely don't want an 18-year-old to receive a large inheritance in a lump sum. In your will, you can create a testamentary trust to hold the assets for your children. You name a trustee, a responsible adult or financial institution, to manage the money on their behalf. You can set the terms, for example, specifying that the funds can be used for education and healthcare, with the remainder being distributed at a more mature age, like 25 or 30. This is a critically important section, as it's where many people make a costly mistake. A will only controls the distribution of assets that go through probate. Many valuable assets, known as non-probate assets, pass to a new owner outside of your will. The distribution of these assets is controlled by beneficiary designations. Let's be crystal clear. A beneficiary designation on an account will always override what your will says. Here are the most common non-probate assets. Retirement accounts. This includes 401, Ks, 403, Bs, and IRAs. When you open these accounts, you fill out a form naming a primary and contingent beneficiary. The person you name on that form gets the money. Period. Even if your will says, "I leave my entire IRA to my spouse," but your ex-spouse is still listed as the beneficiary on the account from 10 years ago, your ex-spouse gets the money. Life insurance policies. Just like retirement accounts, the proceeds from a life insurance policy go directly to the named beneficiary. Payable on death, POD, and transfer on death, TOD. Accounts, you can add POD or TOD designations to bank accounts and brokerage accounts, respectively. This is a simple way to name a beneficiary and keep the account out of probate. Property, titled as joint tenants with rights of survivorship, JWROS. If you own a house or a bank account with someone else in this manner, the surviving owner automatically inherits the entire property. It does not pass through the will. The action item here is to not only create a will but to also review the beneficiary designations on all of your accounts to ensure they are up to date and align with your overall estate plan. Probate is the formal court process that validates your will, settles your final affairs, and oversees the distribution of your assets. While it has a reputation for being long and expensive, having a will makes it far more efficient. The probate court's job is to confirm that your will is legally valid, formally appoint the executor you named, allow creditors a chance to file claims against your estate, ensure all your final bills and taxes are paid, approve the final distribution of assets to your beneficiaries as outlined in your will. Without a will, the court has to do all this, plus identify your legal heirs according to state law, and often appoint an administrator, which takes more time and money. So while a will doesn't avoid probate, it makes the process a guided and predictable one. So how do you actually create a will? Take inventory. Start by making a list of your significant assets and debts. Make key decisions. Decide on your executor, beneficiaries, and guardians for your children. Choose your method, DIY will. You can use online software or templates. This is the least expensive option. It may be suitable for someone with a very simple, straightforward situation, for example, single, no children, and minimal assets. However, the risk is high. It's easy to make a mistake that could invalidate the will or create ambiguities that lead to legal challenges. Hiring an estate planning attorney. This is the recommended route for most people. An attorney can provide expert advice, ensure the will is tailored to your specific situation and state laws, and help you think through complex scenarios you might not have considered. They can also help coordinate your will with your non-probate assets. The upfront cost is higher, but it can save your family immense cost and heartache down the road. Once drafted, the will must be signed and witnessed according to your state's specific laws to be legally valid. A will takes effect after you die. But what if you become incapacitated and can't make decisions for yourself while you're still alive? That's where these other critical documents come in. Durable power of attorney for finances. This document lets you appoint someone you trust, your agent, to manage your financial affairs if you are unable to do so. This person can pay your bills, manage your investments, and handle other financial matters on your behalf. Advance Healthcare Directive or Living Will. This document outlines your wishes for medical treatment if you become terminally ill or permanently unconscious. It can also include a healthcare power of attorney, where you appoint an agent to make medical decisions for you if you cannot. Together, a will, power of attorney, and healthcare directive form the foundation of a solid estate plan. As you can tell, creating a comprehensive plan involves many moving parts and critical decisions. It's not just about filling out a form, it's about building a protective framework for your family. While it might seem complex, you don't have to figure it all out on your own. Seeking professional guidance can provide clarity and peace of mind. Speaking of guidance, we'd like to thank Fenul Wealth Management for sponsoring this video. A comprehensive estate plan is a key part of the overall financial advisory and wealth management process. Working with a team of professionals can help ensure that all aspects of your financial life, from investments to your final wishes, are perfectly aligned. You can find more information about their services at fenulwealthmanagement.com. Creating a will is a fundamental act of financial responsibility and a true gift to the people you love. It ensures your wishes are honored, protects your children, and makes a difficult time significantly easier for your family. Don't put it off. Thanks for watching Money, Finance, Wealth. We hope this video has demystified the process and motivated you to take this important step. And before you go, please give this video a like, share it with someone who needs to hear this, and subscribe to our channel for more informative content on all things money, finance, and wealth. Your support helps us continue to create valuable resources for your financial journey. Thanks again for watching, and we'll see you in the next video.